Fans of North Carolina's growing craft beer industry have found themselves not only enjoying a host of specialty beers, a growing number of those beers, but they've also been witnessing a fascinating debate over what comes next for this industry. Rick Henderson is the editor-in-chief of Carolina Journal. He's been following this story closely. Rick, welcome.
Thank you.
First of all, there's now a legal challenge. There's a lawsuit involving the craft brewing industry. For what?
It's for the limit on self-distribution that craft brewers face, and also for the regulations that craft brewers face when they go to an outside distributor and basically enter a contract for some outside distribution company to handle selling their beers off premises to retailers, bars, restaurants, and the like.
This was an issue at the General Assembly, but evidently the craft brewers felt like they didn't get what they wanted, which was more economic control of their businesses.
Exactly. Because of prohibition, states have great leeway to regulate alcohol sales. And so because of that, the Commerce Clause, which applies in almost every other line of business in the nation, doesn't apply to alcohol sales. And so the states can then set up very, very restrictive or very, very loose ways of distributing alcohol. In North Carolina, you can buy beer and wine at a lot of retailers. You have to go to an ABC store to buy liquor, and depending on where you live, you may not be able to buy alcohol at all at retail or in restaurants, or you may only be able to get it, say, on premises at a winery. There are wineries in dry counties, so you can't buy alcohol anywhere but at a winery, which is producing alcohol for sale elsewhere. So it's a very complicated sort of system. But anyway, North Carolina set up a law which said that a brewery can produce up to 25,000 barrels, a barrel's 31 gallons, of beer a year, and if it wants to, set up its own sales force, its own distribution system, and sell to whoever it wants to. Once you hit that 25,000 cap level, then every barrel you sell has to go through a distributor who then handles all the marketing, all the sales, all the placement, everything. And there are a lot of other rules involved with that. There was a bill in the General Assembly that would have lifted that cap to 200,000, was brought by 3 breweries in particular that are coming up close to that 25,000 limit. The General Assembly did not pass the bill. And because of that, because they've been fighting this for nearly 20 years, the General Assembly then didn't do it, so the brewers went to court, and they are challenging the constitutionality of this legal system.
So we've got a court case in this industry, and also one of the brewers, a well-known one based in Asheville, has decided to get out altogether.
Right. Wicked Weed, which is one of the very trendy beers in North Carolina because they're involved in something called sour beers, which is a brand new, or a fairly new line for the industry, sold to Anheuser-Busch InBev, which is the owners of Budweiser and others.
The big boys.
The big boys. And that caused quite a backlash in the craft beer community because craft beer makers they have this idea of them being sort of a cottage industry and just a few people involved, and mom and pop make their beer, or this little hippie outfit there that sits back at home and brews a few bottles and that sort of thing. Wicked Weed's gotten very big, and Wicked Weed sold out to Anheuser-Busch, and the craft beer community is outraged, so outraged, in fact, that a charity event that Wicked Weed has run at its facility for years had to cancel this year because 50 breweries that were participating in this pulled out. And they are basically saying that Wicked Weed's okay, get successful, just not too successful. We don't want you to do too well with your business.